Good afternoon, Ms. Hunter.
Again, if I could go through things. You're Sandra Ford. You are a planning director at Marins and have been since July last year. Is that right?
Correct, yes.
You've got a postgraduate diploma in town planning, a certificate in professional planning studies, and a postgraduate certificate in urban design. Is that right?
That's correct.
And you're a member of the Royal Town Planning Institute.
I am.
In terms of experience, you have over 24 years experience in town planning, both for local and central government and within the private sector more recently.
That's correct.
And prior to being in your current role, you were Head of Development Services at Tewkesbury Borough Council with responsibility for development services. Is that right? Thank you very much. Okay, in terms of your instructions in this case, you explained at 1.4 of your proof that you were, Barons were approached by the council in April this year to represent the council at the appeal, and you go on to say about your visit to the site and examination of evidence and relevant policy and so forth, and then you confirm at 1.5 that the evidence you prepared and provide for the appeal has been prepared in accordance with the guidance of the Royal Town Planning Institute and is your professional opinion. Is that correct?
That's correct.
Thank you very much. Ma'am, I'm going to take everything largely as read, if I may. I'm going to skip through. I'm going to use your proof as the basis for my questions, and I'm going to go to Mr. Bassett's proof just to pick up some points and get your response to that, because I think neither you nor Mr. Bassett have prepared a rebuttal to each other's evidence. So I'll just ask you a couple of points on that. Can I just note, please, on page 3 of your proof under these, in the summary, for clarity, you say your evidence focuses on the planning assessment of the appeal proposal relative to or in relation to the development plan and other material considerations, and that you make reference to and draw on the conclusions from the evidence of other witnesses.
That's correct.
So does that was at the time you wrote that was based on their proofs of evidence. You've heard their oral evidence now, so when the inspector understands that you're, insofar as you touch on the specific topic areas we've already heard about, you're relying on the evidence given by the witnesses for the council. Is that correct?
That's correct.
Thank you. And if you could then go ahead, please, to page 10. Paragraph 4.6. I just want to ask you about this. You deal with the issue of the development plans, the relevant policy of the development plan, and whether they're up to date and consistent with the MPPF. So starting with the local plan, what is your opinion as to whether or not the local plan policies which are relevant to this appeal are up to date and consistent with the MPPF?
Yes, Sammy. Well, the policies that we're dealing with, aside from the housing policies, I consider that the policies are up to date and in accordance with the MPPF. The council did undertake a review of those policies as a requirement that's been concluded. So therefore, because the council does not have a 5-year housing land supply, then obviously the housing policies are out of date.
Okay. But aside from those that are out of date due to housing land supply issues and a lack of a review, what's the position with the rest of the policies which are relevant in this appeal? Are they...
That they carry full weight in the determination of the application.
Okay. Similarly, in relation to the neighbourhood plans, what's your opinion on their consistency or otherwise with the MPPF and the weight that's to be given to them?
Again, the neighbourhood plan, I consider that they are up to date with they comply with the local plan, and also they do comply with the National Planning Policy Framework, so therefore carry full weight in the determination. And apologies, the appeal, not the application.
Okay, thank you very much. And could I just ask you, this is one point I'm going to ask you to dip into Mr. Bassett's proof, because whilst we're on this topic, could you take his proof up at page 11? Paragraph 4.14. In terms of, sorry.
Yep. I'm going to do. I'm doing a bit of a mixture of hard copy and also electronic. So
that's probably very sensible.
Bear with me. Sorry. Apologies. What page number was that? Sorry?
It was page 11, paragraph 4.14.
Yes.
And if you just look at that, Mr. Bassett there tackles the issue of consistency of the development plan policies and the MPPF. And I just wanted to ask whether there's any, you said aside from the housing policies, which are not up to date, but you regard the other policies as being consistent with the MPPF and meriting full weight. What's Mr. Bassett's position on consistency? Does he accept that they are consistent or say they're inconsistent?
He says that they are consistent with the MPPF and carry full weight.
Thank you. Okay, can I ask you to go back to your proof, please? I'd like to look now at your assessment of the proposal against the development plan. So could you go, please, in your proof to same page 11? And I'm just going to take you through the policies and ask you to look at the local plan in a little more detail with that. Okay. So the first one that you deal with there in the local plan is S1, Sustainable Development Principles. Can I ask you, is it possible, I don't know how you arrange your documents actually, have you got the local plan in hard copy? You have,
yeah,
excellent. Yeah. So could you go in that to page 30?
Yes.
Can I just go, so I'm just going to ask you about the relevance of particular parts of it, because obviously some parts may be relevant and some others not relevant. So we see that all development should make a positive contribution towards achievement of sustainable development by improving economic, environmental and social conditions of the area wherever possible. And then this will be achieved by a number of bullet points. I'm just going to ask you whether particular parts are relevant or irrelevant, okay? So meeting the most development needs within or adjacent to existing communities, having regard to the settlement hierarchy.
That's relevant.
Making efficient and effective use of land, particularly land which has been previously developed.
That's relevant.
Okay, just but in parentheses on this site, is it previously developed land?
It's not previously developed land, no, but the issues around making the efficient and effective use of land, then that is an issue that's applicable.
Yeah, Mr. Carr, I think, particularly referred to it. So then the third bullet point, also on the same topic, making efficient use of land by optimising the use of sites, while also reflecting the character, accessibility and infrastructure capacity of the area. Is that relevant to this appeal?
Yes, it is, yes.
Okay. And what's the approach that's to be taken? Are sites to be developed to the maximum extent, come what may, or what approach should be taken?
What this criteria is setting out is that when you're developing a site, you need to optimise the land that you have got. However, as part of that developing the site, you have to take notice of and make sure that you are taking into account the character of the actual site itself, the accessibility of the site, and the infrastructure and the capacity of the area. So basically, this is what I call a criteria-based policy in relation to how you assess developments within a particular location.
Okay, thank you. And there's a series of there's a number of bullet points, and I won't take you through absolutely every one. So I'm going to focus on some. No doubt you can be asked about others in cross-examination if it's thought relevant. Could you go over the page to page 31? Minimising the need to travel by promoting development in locations where there's access to a broad range of jobs, services and facilities which are accessible by foot, cycle, public transport, with reduced reliance on the private car, in brackets, policy HC19. Is that relevant in this appeal?
Yes, it is.
And 4 bullet points down from that, seeking to secure high quality, locally distinctive and inclusive design and layout in all development, relevant or irrelevant?
That's relevant.
Thank you very much. You then go to policy S2, which is the next policy that you refer to in that part of your proof. So, but I'm going to stay within the local plan. You don't need to keep going back between them. So we have the settlement hierarchy policy, and we see proposals for new development will be directed towards the most sustainable locations in accordance with the following settlement hierarchy. This will ensure development reduces the need to travel and promote sustainable communities based on services and facilities that are available in each settlement. The use of previously developed land and buildings will be encouraged. And then we see in the first tier of the settlement hierarchy, market towns, Ashbourne appearing. So there's no dispute Ashbourne is a first tier settlement in the hierarchy?
No, there's no dispute on that at all.
Is the appeal site within the settlement?
No, the appeal site is outside of the settlement boundary, and as such, the policy goes on to, well, the local plan goes on to say that anything that is not within any of the various settlements will be defined as development within the countryside, and that's in policy S4.
Okay, so, but the bit you're referring to in that policy we have at the bottom are the rural areas?
Correct.
All other areas, including villages, etc. Is that what you're referring to?
Yes.
Okay, thank you. Right, then can I ask you about this? But just immediately below that, there's a heading, Settlement Development Boundaries. Settlement development boundaries have been identified in the plan. The boundaries seek to define the physical extent of those settlements which are considered to be most appropriate and sustainable given the scale of growth envisaged. I'm going to skip ahead a bit, and we see the last 4 lines what the plan says the purpose of settlement boundaries is in this plan. And it says it's not to limit the total supply of land for development, but to assist in directing bulk development towards the most suitable and sustainable locations across the district with respect to the hierarchy, and to define the intended relationship between the settlements and the countryside beyond. So can I just ask you to consider that in the context of the proposal before us? The purpose of the settlement boundary is to identify, firstly, the most suitable and sustainable locations across the district. So what does that imply about the appeal site in terms of its sustainability?
Basically what they're saying, that because it isn't within the settlement boundary, it is outside and covered by policy S4, that it's not a sustainable location.
Okay. And the second part of it, the intended relationship between the settlement and the countryside bound. Can I just ask you this question? Sorry, remember me. What would be the effect of the appeal being allowed and planning permission be granted in terms of the relationship between this settlement and the countryside? Would it stay the same or change?
It would change.
Okay, and we'll come across all the details of what that means in its compliance with policy a little further on. Okay. You tackled policy S3 in your proof, but we see policy S3 is development within defined settlement boundaries. Is that applicable in this case?
No, basically the policy just basically sets out how you deal with developments within settlement boundaries, and as the site is outside, it's not applicable.
Thank you. So going on to S4, which I think there's no dispute, is applicable and is cited in the reasons for refusal in various places. Could we look at that then, please? Because that's obviously a key policy. Outside defined settlement development boundaries and sites allocated for development, the council will seek to ensure new development protects and where possible enhances the landscape's intrinsic character and distinctiveness, including character, appearance and integrity of the historic cultural environment and the setting of the Peak District National Park, while also facilitating sustainable rural community needs, etc. And it says planning permission will be granted where. And then I think this is common ground, so I may have read on. Mr. Bassett says this about it. He says he accepts that none of the not bullet points, lettered points, are engaged here between A and I think it is L, save for letter I. I just want to check. It's agreed, isn't it? Between A and I, the only relevant part that the inspector needs to consider is I. Is that your position as well?
Between those you've referenced, yes, it's I.
Yeah.
Yes.
And then even within I, we have a number of different forms of residential development described. I just want to ask, again, I think it's common ground that the final bullet point is relevant and the one to be considered. Does the appeal proposal fall within any of the other bullet points, or is it just potentially the last one that it falls in?
It falls within the last one, because also we are dealing, the council has admitted that it does not have a 5-year housing land supply, so it is that one that we need to take into account, and the others, the other criteria under I do not come into play.
Okay, and so what if we put together the opening words of the policy and this bullet point in letter I, we see planning permission will be granted for development where ... development, it comprises development on non-allocated sites on the edge of the defined development boundaries of first, second and third tier settlements in circumstances where there's no 5-year supply, subject to consideration against other policies in the local plan and the provisions of the MPPF. So is it a policy that planning permission will always be granted on edge of settlement sites or only in certain circumstances?
No, it's only on certain circumstances because of the inclusion of the subject to consideration against other policies in the local plan and the provisions of the MPAPF, and obviously there are other criteria listed as well.
Okay, thank you very much. We can leave the local plan then for a moment, and if you could go then to the specific topic areas we've been hearing about. First of all, highway safety, which you deal with at page 14, going over to page 15. I'm not going to ask you to read all that out because it's essentially, I think, it's a summary of Mr. Carey's evidence.
It is, yes.
It is. What I'm just going to ask you about is where that leads to in terms of compliance or non-compliance with development plan policy. And so, could you help me with, first of all, how it complies with policy S4R, because you've highlighted that as relevant to the highways issues. So we're still on policy S4 in the local plan, bit below letter I.
Yes, so policy S4 criteria I relates to the permission will be granted where, and it says it will have safe access and will not generate traffic of a type or amount which will cumulatively would cause severe impact on the transport network or require improvements, etc. So I think for me the key issue there is it will have a safe access, and as we've heard in the proof of Mr. Carey, which I rely, the evidence that Mr. Carey put forward was that following the refusal of planning permission, a road safety audit was undertaken. And we have heard in evidence subsequently that 2 road safety audits have been undertaken, and they have both reached issues of safety concerned around accessing the site. So, but purely relating to Mr. Carey's evidence, he's highlighted the fact that there is safety concerns have been raised, and so therefore, in my view, that does not comply with S4 criteria R, which does require to have a safe access. Okay,
so next question bottoming out on this. If the inspector accepts Mr. Carey's evidence, what conclusion do you say she should reach in relation to compliance with policy S4 as a result?
That the appeal is not in accordance with the development plan and it's contrary to it.
Thank you. And also, could I ask you to turn then to policy HC19? Okay, and I just want to ask you this. We see at the top of that, the District Council will seek to ensure that development can be safely accessed in a sustainable manner. If Mr. Carey's evidence on highway safety is accepted, what conclusion should the inspector draw in relation to compliance or otherwise with that part of that policy?
that the appeal is not in compliance with the development plan.
Okay, thank you. Then can I ask you, going back to your main proof of evidence, go to the section on page 15, site accessibility by sustainable modes of transport. Again, I'm going to adopt the same approach, not ask you to read out what is essentially a summary of Mr. Carey's evidence and possibly Mr. Lally's as well, who also touches on that. And I'm just going to ask you what conclusions the inspector should draw in relation to compliance with development plan policy in light of the council's witnesses if their evidence is accepted. So first of all, sticking with HC19 because we're already in it, could you look at, please, first of all, the opening words of the policy, safely access in a sustainable manner, minimising the need to travel, particularly by unsustainable modes of transport, and delivering the priority to the adoption of the transport plan. And then we have, just like the first bullet point, delivering sustainable patterns of development. Would the appeal proposal conform or not conform with that if Mr. Carey and Mr. Lally's evidence is accepted?
It would not conform.
Okay. Similarly, second, I think actually I'll just focus on the fifth bullet point. Sorry, maybe is it the fourth? Sorry, I have a dot on my screen that may have gone wrong. The fourth bullet point is actually ensuring the development of social. Fifth. It is the fifth bullet point. Requiring that all new development is located. I'm sorry, Mum. Excuse me. Just. Yeah, it could be, Mum. I'm counting you. Yes, sixth bullet point, sorry, thank you. Requiring that new development can be integrated within existing or proposed transport infrastructure to further ensure choice of transportation method and enhance potential accessibility benefits. Was the proposal conform or not conform with that?
It would not conform.
Thank you. Okay. And the third point, bullet point from the bottom, promoting the maintenance and introduction of appropriate facilities to support cyclists, pedestrians and horse riders, ensuring the development supports the use of local cycleway and pathway networks to improve choice of travel and ensuring safe access developments on foot and by bicycle. Are there such facilities to support such modes of transport? Are they sufficient to comply with that or not?
No, they're not.
Thank you.
So safe access on foot and bicycle, can you just elaborate for me, Mrs. Ford, just on why it doesn't comply with that?
Yeah, so if we read the policy itself, it talks about, it's having the key issue there is around having them actually from the site itself and having a choice. So I think the key issue is because we've only really got one point of access to the site, that it doesn't actually doesn't improve a choice of travel. Yes.
Thank you. Thank you, Mum. And can you turn next then, please, to policy PD1, which is page 51 in the local plan. And again, I'll read the introductory words and then draw your attention to particular bullet points. So we have the District Council will require the layout and design of new development to create well-designed, socially integrated, high-quality, successful places where people enjoy living and working. All developments should respond positively to both the environment and the challenge of climate change, whilst also contributing to local distinctiveness and sense of place. Number of bullet points on then, I think, design issues, or exclusively design issues. Then at the bottom, fourth bullet point from the bottom, requiring developments are easy to move through and around. incorporating well-integrated car parking, pedestrian routes, and where appropriate, cycle routes and facilities. Any comments on that and its relevance, and whether or not it's complied with, if it is relevant?
I think the issue that we've got there is in relation to having the well-integrated pedestrian routes and easy to move through. So I think what we've heard from the evidence of both Mr. Carey and Mr. Lally is the failure to integrate the site within the surrounding area and giving a choice of route for pedestrians and cycle facilities.
Okay, so integration and choice of routes. Thank you. Okay, then the penultimate bullet point. Any comments on this? Requiring the inclusive design of development, including buildings and surrounding spaces, to ensure development can be accessed and used by everyone, including disabled people. So, is whether or not the design of the development in this case is compliant or not in terms of its ease or ability to be used by people who are mobility impaired?
I think there's a couple of points here. I think the first one in relation to the ease of access and how you can move around the place and get access to neighbouring facilities is that we've heard due to from the access to the site, the gradient and the slope that you have to go up to walk from the actual site to nearby facilities, that would be that would put people off who potentially who may have walking issues or disabled people. But I think the other issue I want to draw a point on in that particular requiring inclusive design of development. Again, we talked about yesterday the quad blocks as well. I think there's an issue there about the quad blocks and the fact that they don't have amenity space. So that is a bit of an issue around that inclusive design, and this is including it's the outside spaces as well. I think people will be disadvantaged.
Thank you. Can I then ask you to go to the neighbourhood plan, please, next, which is core document 5.3. And when you have that, if you go to page 38 in policy TRA1, transport.
So I have so many documents.
No,
I'm trying to make sure it's
sympathise.
the right one.
I thought we've actually been quite light in this part of the inquiry.
My system seems to have locked. Sorry. Just bear with me.
You won't be able to, John, so you won't be able to, she's having trouble with the computer. You haven't got the neighbourhood plan. Thanks.
Sorry, yes, I've got it.
Oh, you got it.
Sorry,
You got
yeah.
it. Brilliant. So, have you got the page?
Sorry,
Yeah.
which page, sorry?
It was 38. It's quite a short and sweet policy, which has its virtues.
Yes,
You got that
sorry,
now? Okay. So in order to assist the shift to more sustainable forms of transport, development proposals should, proportionally to the scale and nature of the scheme, ensure, one, convenient links to public transport services to help reduce car dependency. If Mr. Carey's evidence and Mr. Lally's evidence is accepted, again, what would you say about compliance or non-compliance with this part of the policy?
It's not compliant with the policy.
Okay. And secondly, priority for pedestrians and cyclists in the design and layout of the development, including for people of all levels of mobility. Any comment on that?
I think one of the key issues is that because of the layout and the access from the site, which has the steep sort of gradient, then that would cause issues with people who are less mobile and less able.
Okay. And does the layout of the development along the long spine road give priority to pedestrians and cyclists or car users?
The the dominant feature is for car users. Obviously, pedestrians can obviously use the footpath naturally, but predominantly is for car traffic to access the site.
Okay. Okay then, thank you for that. I think that, could you go back to your main proof of evidence then, please? And if we go over the page, to page 17, Mr. Design and Layout, Mr. Lally's evidence. Again, just if you could assess the proposal's compliance with policy PD1 first in the local plan in light of Mr. Lally's evidence. So if you take that up, it's page 51 of the local plan. Yes. I just trying to identify with the inspector the parts of the policy that you say are engaged or relevant and whether they're complied with or not.
Okay. So the policy PD1 lists out a number of criteria in which the policy will be achieved, and it lists a number of bullet points. So, for example, the first one is requiring all developments to be of a high-quality design that respects the character, identity, etc. of Derbyshire Dales, townscapes and landscapes. And if the evidence of Mr. Lally is accepted, then obviously the scheme would be in contrary to the actual the policy itself, because it fails to respect the identity as being set out. The third bullet point is around the site appraisal and design qualities reflecting there's a clear understanding of the site context.
Yep.
Context. Sorry, and I think it's and this is the point that was discussed over the past couple of days around how the design has evolved in the design context and what that's taken into account. So if Mr. Lally's evidence is accepted, then that would be contrary to the policy here.
Okay. And can I ask you about the fifth bullet point in particular? I think we dealt with other ones, but requiring development contributes positively to an area's character, history and identity in the terms of various things: scale, height, density, layout, appearance, materials and relationship to adjacent buildings and landscape features. What's the implication of Mr. Lally's evidence in terms of compliance with that bullet point?
I think, as we heard from Mr. Lally, one of the key issues around the layout and also the relationship to the landscape features. No harm is being asserted to the landscape, but it's how the landscape context has been taken into account, which has arrived at the design of the actual scheme itself.
Okay, thank you. That's all I want to ask you about that, unless there's anything the inspector would like to ask. I will move on to planning balance. So could you go back to your proof, please, page 21.
So just on that point, should I discount page 19 and 20?
19 and 20, sorry, Mark.
Of Mrs.
Oh, sorry, so no, I did want to do that. I beg your pardon, I did want to address that. Sorry, I've skipped ahead a page. Thank you for that, that's helpful. Sorry, the inspector's quite right. Flood risk and drainage, let's just appraise where we are on that, because there's been obviously a change in the council's position since you drafted your evidence just yesterday. Given the council, the withdrawal of that objection on the basis that we've gone over, we see at the end of that section, you say you consider the lack of information attracted significant negative weight in the balance. What's the position now on that?
Well, obviously, since I've written my proof, we've had the various rebuttals, and we've also had the verbal evidence as near us today. So, and as a result of that, I'm now satisfied that information is now in the domain, and we've discussed the conditions this morning. So therefore, obviously, I'll amend my comments in relation to flood risk and drainage, and therefore concede that there is no longer any harm in relation to those particular issues.
So the lack of information which has now been supplied and satisfied Mr. Bold means that, again, I'll lead on this because I don't think it'll be controversial. You no longer say it attracts significant negative weight in the planning balance because that information has been provided, albeit through the inquiry process.
That's correct.
Okay. So question then is, that affects your conclusion on compliance with the development plan overall. Do you reach any different conclusion as a result of that change, or the same conclusion on compliance with the plan overall?
In connection with the planning balance overall, I still maintain that there is the development is in conflict with the development plan. I set out within my proof. Obviously, I've amended my comments in relation to flood risk and drainage, but overall, there is a conflict with the development plan.
Okay, thank you. Similarly, you've acknowledged in your proof, again, it's common ground. This is a paragraph 11 case because of the shortfall in the 5-year supply. Test is whether the adverse effects significantly, demonstrably outweigh the benefits. You conclude in your written text that they do. Does the resolution of this part of the council's objections change that conclusion?
No.
Okay, thank you. So then if you could go out then on to the planning balance. In fact, I won't ask you. I was going to ask you to read that out, but I don't think I need to in light of what you've said. So what I would just like to do is ask you some questions about the table that you set out under the section on planning balance. And I want to ask you, first of all, this. The first public benefit that you identify there, which we see both you and the appellant give significant weight to, is the boost to the housing supply as a result in a lack of 5-year supply situation. And a question I just want to ask, obviously the inspector's just heard evidence on the parties' different positions on the level. Essentially, it appears to be, I know we're awaiting the precise figures, and excuse me for being approximate, but I think it sounds like it's going to be about the difference is going to be about 3 years or 4 years. Can I ask whether or not, if the inspector, again, can I take it as for granted that you've proceeded on the basis of Mr. Hayes' evidence on that?
Yes, I did, yes.
But if the inspector were to conclude, accept entirely the appellant's case on that and say it's only about 3 years, would that materially affect the way you have struck the balance, either in terms of development plan compliance overall or the tilted balance in MPPF paragraph 11?
No, and my reasons for that is, the council have always maintained that they do not have a 5-year housing land supply. So then they're not, you're absolutely correct, the tilted balance is then applied. But then the issue is then what are the adverse harm then to the actual sort of allowing the development to go ahead. So I do give significant weight to the fact that there would be housing supply and also affordable housing within the area. However, the harm, as from my perspective, is the failure to demonstrate the safe access to the site itself, and also the accessibility of the site. And as we have discussed, the failure to comply with the placemaking and the urban design policies within the plan.
Okay. Thank you. Now, one other question I wanted to ask is in relation to economic benefits. In the table that you've set out at page 23, you say you give moderate weight to the economic benefits of the development.
That's correct.
And we see that you say in your table you identify the appellant as giving significant weight to those. What was the chronology in this? Did you have Mr. Bassett's proof when you wrote this table, or were you relying on some of the statement of the appellant's position on that?
No. When I wrote my proof, I was relying on Mr. Bassett's. I think it's the statement of case.
I'm not sure. I don't know if it was Mr. Bassett's, but yes, okay, good.
And then subsequently, when I've seen Mr. Bassett's proof of evidence.
Yep.
Mr. Bassett has also given economic benefits moderate weight.
Okay. So presumably then you would agree with that?
Yes.
Okay, thank you. Then, could I just ask you to read the final thing, your summary, and then I'm going to go and ask a few questions about Mr. Bassett's proof. So could you just read paragraph 10.1?
In conclusion, there is a clear conflict with the development plan and the NPPF as a whole. Whilst there are benefits associated with the appeal proposals, as I have set out above, I do consider that the adverse impacts of approving this appeal scheme will significantly and demonstrably outweigh the benefits when assessed against the policies in this framework taken as a whole.
Thank you. So then could you take up Mr. Bassett's proof again, please? Could you, when you have it, could you go to page 12, paragraph 4.16? Sorry, I'm just... No, I thought I had oh, there it is, sorry. Yes, so Mr. Bassett there talks about the local plan review, and he says he gives it no weight at the moment because it's at a very early stage. Do you agree or disagree with that? Are you content?
I agree.
Yeah, thank you. I'd just like to ask what that implies. We obviously have an extract from the Sheila, which the SHLA or the Sheila, which looked at the site and gave it green light in some respects, red light in other respects, and an overall comment. Can I just have you, if we're not giving any weight to the local plan review process, what weight would you give to any particular expressions of views in the Sheila?
Until the local plan is adopted, then you really can't give any weight to any documents that are produced as part of the evolution of the local plan.
Thank you. Could you go on in Mr. Bassett's proof, please, to page 16, paragraph 5.9? You may have answered this already, but you see there the appeal site is adjacent to, I think you should read, but outside of the settlement boundary, and as such it's classified as countryside as set out in S2, so that's the settlement hierarchy policy in the local plan. Agree or disagree with that?
I agree.
Thank you. If you go on, please, to page paragraph 516, page 18. He notes that there's a difference in wording between policies HC1 and S4, whereas HC1 says Council will give consideration to approving development on non-allocated sites when there's no 5-year supply, whereas S4 says planning permission will be granted for development on non-allocated sites on the edge of defined settlement boundaries. He says that he doesn't in practice identify a material difference. The wording's different, but it's not material because of what both of them say about consideration being given to other policies and compliance with the NPPF. Do you agree or disagree with him on that?
I agree.
Thank you. Yes. Pages 25 and 26, please, next. Now, we see, just looking slightly over the page, we see he says that the appellant statement of case sets out the planning history permissions on adjacent nearby development sites or identifies them. And he says he sees no material difference between those development sites and the proposed development in respect to distance to the town centre or access to public transport. And then he identifies what he's specifically talking about. So we're talking about Red Row Homes to the north, Acorn Drive. We're talking about David Wilson Homes, Landoff Road, Derby Road to the east, and then a Cameron Homes site also off to the east. And just want to ask you this then. He says no material difference in terms of those sites and their distance to the town centre or access to public transport. Do you agree that there are no material differences, or do you disagree?
I disagree, because I think certainly in relation to all the other schemes that they have better accessibility to the services within Ashbourne, and also looking at the plans, particularly the David Wilson Homes plans, there is a lot of different footpaths and connectivity that is within the site itself. So I think the accessibility and the connections, that they are quite different to actually what's proposed within the appeals site. So I don't agree that I think there is a material difference between those particular sort of sites in question.
Okay, can we just try and identify that on the plans for the inspector? So if you could take up Mr. Bassett's appendices, and we'll look at the Redrow Homes site plan first.
Just put this way.
I think there are a couple of them actually, but just have to refer to this one. So the first...
Sorry, I'm not there. Bear with me. Bear with me.
I will let you go. I'm just going to explain. I don't think that they've got a sequential pagination, so I'm going to have to give the PDF number. It is the first document, Mum, unless you do have pagination. I apologise, I'm not sure I can see any anyway, but it's the 92nd page of the PDF. It's in Appendix 1, and it may be it's the Redrow. Yeah.
Was it 92 of the PDF?
It was 92 of the PDF, I think. So Henmore Gardens, Ashbourne, in the left-hand corner. And a big black mark in the middle. It may not matter, Mum. If you had another plan of Redrow site, it may not be problematic unless... I just wanted to ask, do you have page 92 of the PDF?
I do, yes.
And so you've got the plan. I've got Henmore Gardens in the left-hand corner.
It's on
Redrow Homes in the right-hand corner.
Yeah.
Yeah, it's got a big black square in the middle.
Quite a way through.
Yeah.
But
It's about the way through.
that one, big square, that's it. That's the most identifying thing. I just wonder whether you could help me with this. Can you see on the right-hand side of the plan where Wyreston Road goes south to north, or north to south, north-south road, and then before you get to the roundabout at the top, on the right there's a road named Willow Meadow Road.
Yes.
And then opposite that, on the other side of the road, what do we see leading into the Redrow development?
There is a footpath.
Is there anything like that on the appeals site?
No.
Can I ask you next to go on to, this is page 105 of the Appendix 1 again. It's the biggest appendices because it's got all the decisions and relevant documents. So it's a page 105. And there's an inspector's report or decision, Mr. Felgate. Land of FUL, Derby Road, Ashbourne. And page 105 is paragraph 26 of that decision. Yeah. So we can see that there's reference. Sorry, Mum. No. Yes, with the reference there to the site being crossed by public footpath forming part of the Centenary Way and Bully Prince Charlie Walk, and reference to views along that. Just wanted you to note that, and says to the north of it, it continues through the built-up area in any event. And then can you go to page 110? Sorry, it's not 110, 108. 18. So that would be about 13 pages from where we were in the inspector's report or decision. And there is a plan, I think it was David Wilson Homes. Read the reference. Plan reference S7240/100/01H. And I just want to ask about, again, whether the public footpaths that we see denoted across the open space there and on other parts of the development, whether or not there's anything similar in or corresponding to them in the appeal proposals.
No, this particular site layout, this does include a number of different footpaths across the site leading to the main roads, but also there are footpaths leading across within the development and outside the development as well. So I think that is quite different to the appeal side.
Okay. Thank you very much. Thank you. When you're ready, you can put that away and just go. I'll take you back to Mr. Bassett's proof. Okay, could you go next, please, to page 32, paragraph 547?
Five points.
547, paragraph 547 on page 32 of Mr. Bassett's proof.
Yes.
Sorry, I'm making you jump around. It won't be. There's only, I think, one more. In fact, no, this is the last one because I've already asked you the last question. This is my last question about this. So this is about the pedestrian link or previously proposed pedestrian link to Premier Drive. And we see Mr. Mr. Bassett's evidence is on this is that whilst, if I'm going to take back to 5.46 to be clear with the context, he says the absence of the access to the west doesn't render the development unsustainable, as he says Mr. Price demonstrates, and it's also not a situation where access to a significant provision of services, facilities in very short proximity is being denied by an access of the western connection. But then he goes on to say, notwithstanding that, I consider that a western pedestrian connection would have comparatively modest benefits, and he accepts that there's a level of benefit to choice in the principle of permeability, and so he considers that there is an element of harm of not having a western connection, albeit he says the harm's limited because of the distance it would be anyway to the services and facilities if the route was available. Just breaking that down, he accepts that there is an element of harm. Do you agree with him on that or disagree with him on that?
There is definitely harm to the scheme, yes.
Do you consider it to be limited, as he does, due to the distance that there would have been anyway between the site and the facilities to the west?
I think the lack of a western pedestrian access, it is quite significant to the scheme because you've only got that one access point. So I think having accessibility, the more choice, as the policy clearly sets out, it's all about giving people choice of accessibility. So therefore, just having one, that is quite limited for a scheme of this size. So I think there's significant harm not having a pedestrian link.
Thank you very much. Those are my questions. Thank you, Ma'am.
Okay, thank you. Do you want a break and then have a go at cross-examination?
Yeah, I'm happy to. I'm slightly. I think my estimate was an hour and a half. I think I'm going to be
an hour. And a bit tight. Yeah.
Yeah, it is tight, and I think it's probably going to make me rush.
Right.
As well, because I know it sounds ridiculous, but the way my brain works is I'm already thinking about having to move all the documents. But I'm happy to have a crack, but I don't think we'll get finished. So the question is, do you want the witnessing further overnight?
I don't think. Certainly, it's not a problem. I mean, we couldn't. I don't think we'd be talking about it. It won't cause any problems. So,
is there an easy place to split that's manageable?
I'm not sure there is really. No.
Well, are you happy to maybe take the hour, and
Yeah.
then that gives you half an hour to clear documents and stuff.
I can do what I can, but
Within an hour, yeah.
Yeah, but I don't think it's going to get me where I need to be.
No.
So as long as we're all on the same page
There's
with
no
that.
rush. I think just make a start, and
Yeah,
we can pick
absolutely.
up again tomorrow.
That's fine.
Okay, do you want just 5 minutes?
Yeah, 5 minutes would be
Break or
helpful,
so?
thank you.
Yeah. Okay.
Yeah.
Oh, don't worry, Wentz are all back here.
Just always like to make it out of me.
I know, I thought about that now. I thought, sod it, we know who's here.
I just need to make sure.
Short and sweet, on your thing. Pretty sure there's something going on. I think they'll be, we usually have some.
Are you waiting for him to come back? Does he know you're waiting for him? Does he definitively know you're waiting for him? Yeah, because either you've got a long way to go.
Oh, it's fine now. Do this. Just get them figures up. Right, okay, yeah. With regards to private, now, that's what you get. That's an extract from 1213. We've got in there.
Oh, yeah.
Yeah, mission data, etc. Yeah. This is in the exercise 6.2.
To be fair,
You're freezing, aren't you?
it's either what, it's like a greenhouse's route apparently, it's either one way or the other. So Personally, I still prefer being called, yeah. Just my hands though.
I'm fine with that.
Yeah.
I just did it back in.
That's what I did. The weather's been nice and bright. Yeah, that's what I saw. It's been warm. Way lots. Yes, it's been hot wasting all this glorious weather stuck inside, yeah.
Well, I'd like to be on the 1.5 hour side, but I guess we'll just have to see where we get to. Yeah. I thought we'd knocked it down to 1.5 to 2. Sorry, Mum. Sorry, that's fine. Thank you. Chair just keeps bashing into the wheel. Yeah. Oh, thank you.
I just spoke to.
Yeah.
That's the position we had.
Yeah.
This is revised following discussion.
That's great. Yeah.
Those are agreed. Yes.
Yeah. Lovely.
So
Thank you.
Self.
Yeah. Fantastic. That's very helpful. Thank you.
The table now must be yourself, Alison, as well. It's,
Yeah.
What Mike's done here, this is just clarification as well. That it wasn't in the. Just the actual clarification on the few plots back there.
So this is new.
You're making your way,
And I'm really cold. I'm really cold as well.
The second one is.
So that's in accordance with 6.
Okay. Yeah. All right. Yeah.
I bought Autumnus first because it's lovely where I was in the UK. It came with freezing.
It's just an extract from
My office space is in Stratford.
AMR.
Oh, right. Okay.
Very nice.
Yeah.
It's so hot when I left on Monday.
So it had
Then
started
it's
in our records.
boiling.
Yeah.
We've got 20
And then I came over here, it's like-
26 on construction, 20 on started.
I see.
I
So
do
the
feel
UC
I
means
bought one
under
cardigan.
construction.
Oh my gosh.
And NS is non-started.
I spent yesterday watching online.
And then the rest is just a
Yeah.
calculation of the, or tabulation of the form.
Okay.
Watched it all online, but it was.
Thank you.
in the hospital. Saturday hospital.
Nice.
It's a bit different here.
Do you think it was what like doing that? Yeah.
Hey.
Okay. Yep. Oh, yeah, sorry.
identifies in the monitoring period 2018-19 that we'd identified that 38 were under construction and 9 not started. It's the columns that are next that are...
Presume it's the pink highlighted columns.
Yeah, the pink highlight is the site. And it's the 2 columns next to the word started, to the left of the word started. Three to the left of that, no. Yeah, 38 and 9.
38 and 9. Oh, okay. So the 38 means 38 start.
I don't know why that's come to.
9 not start.
That's in 2018.
Okay. So what you're saying is slow progress.
Yes, we're saying that there is evidence to say that, work had commenced going back, which is part of the discussion we had this morning.
I probably should have asked, but I'm assuming you're okay with receipt of this evidence.
It's fine. It's fine, ma'am. I was shown it in advance, so it is helpful. To be fair, yeah.
And are you happy? Was there anything you wanted to come back with on that, Mr. Denning? No, it all looks correct. You made this fabulous. Okay, that's really helpful. Thank you very much for all your hard work on that. Okay, right. When you're ready, then, Ms. Oakley.
Thank you. Just put this out of the way. Good afternoon, Mrs. Ford. If I could just start with your proof, please. So I just want to dip into your summary proof section first, paragraph 2.4, page 3 of your proof of evidence. And you visited this briefly in your evidence in chief, but I just want to be sure about the current position. You tell us there that your evidence focuses on the planning assessment and you make reference to and draw on the conclusions of Mr. Lally and, we're limited to Mr. Carey now. I won't reference Mr. Ball for now. But it's fair to say that it's not just a sort of a reference and draw on, is it? You do rely on their assessments for your conclusions.
Yes, that's correct.
Yeah. So it's a bit of a trite point, but obviously if the inspector prefers the appellant's position on that, then that would fundamentally change your evidence.
It would, yes.
Yeah. And you would conclude in that scenario, the same as Mr. Bassett, that permission should be granted without delay because it would be in accordance with the development plan.
Well, obviously, if the inspector sort of accepts the evidence, then yes, the inspector would allow the appeal. Yes.
Yeah, so but it's just, I just want to be clear though, that if that's the position and the inspector finds the appellant's evidence to be preferred, a policy point, it's grant without delay, isn't it, is the actual imperative from the MPPF, because we'd be in accordance with the development plan.
If the inspector finds your
yes, of course, yeah, it's predicated on that basis.
Of course, yes.
And just, again, I think there's nothing between us on this, but let me just be clear that there isn't, because I always like to make sure I know where I stand. Paragraph 2.5, you tell us that the starting point for assessment is the development plan. And of course, there's a statutory presumption in favour of the development plan. Can we agree that?
Yes.
And we know that we have to interpret the development plan policies, take them as a whole. Is that fair?
It is, absolutely, yeah.
And the MPPF, important though it may be, is a material consideration rather than part of the development plan, so it doesn't have a statutory presumption in favour.
That's correct.
Yeah. That's very helpful. So can we dip in then, please, to the paragraph 2.10 of your proof, so overleaf on page 4. let's just see if we can agree this. You note that the MPPF is engaged at paragraph 11D, but can we just go to the local plan policy S4I that you've already picked up with Mr. Hunter in your evidence in chief? Sorry, I'm going to roll up somebody with a folder. So I think it's back to page 30. That's one.
36?
It is 36, thank you. And it's again, I'm not sure there's anything really between us on this. If we go to the bullet points under I, so it's I bullet point 8 on page 37. Development on non-allocated sites on the edge of defined settlement development boundaries in first, second and third tier settlements in circumstances where there is no 5-year supply will be supported, subject to, of course, consideration against other policies in the plan and the provisions of the MPF. But this isn't just a paragraph 11D case, is it? This is an actual development plan policy.
That's
that,
correct.
of course, the appellant says the scheme benefits from.
Yes.
Yeah. Can I just say, where do you take that into account in your evidence, Mrs. Ford?
I actually don't make it explicit. But I do sort of make sure that obviously that the development plan is the starting point for the assessment of the application, so the appeal. So I do list what the policies are, and I specifically make reference to the fact that I'm acknowledging that the NPPF makes it very clear that where a council does not have a 5-year housing land supply, then obviously the tilted balance is engaged.
Yeah, and I understand that, Mrs. Ford, but let's just be absolutely clear about that, because policy S4 doesn't apply a tilted balance, does it?
No, it doesn't, but it does set out a criteria-based, it is a criteria-based policy that when you haven't got a 5-year housing land supply, this is a policy which then does allow you to say, well, actually, we'll consider developments within the countryside subject to caveats. So it's still a criteria-based policy.
That'll work from my perspective. I can move on, ask the question, got an answer. I'm not going to keep going over the ground. So just in terms of bullet 8, though, let's just understand this, because the local plan policy supports development on unallocated sites on the edge of defined settlements, not just in first tier settlements, it's actually first, second and third tier settlements, isn't it?
Yes, that's correct.
And can we agree that if we're looking at the difference between a first, a second and a third tier settlement, that from a sustainability perspective, development at the edge of a top tier settlement is bound to be preferable?
I think I'd have to look at the various sort of sites in order to make that assessment. I think by default, common sense would probably say, but I think you'd have to look at the individual sites to say whether one is more sustainable or not.
Well, okay, so there may be an issue between us on this, because isn't it right that the settlement hierarchy itself reflects what this plan says is a sustainable pattern of development?
The policy 2 sets out the development hierarchy, yes, absolutely, and it sort of sets out, the smaller settlements and accessible settlement, yes. But there are, for example, on the third tier, there are accessible settlements with some facilities. So you could have a situation that you have a site which actually could be more sustainable than Matlock because of its particular location.
I'm sure that was a slip of the tongue, but we're in Ashbourne. But can I just take you to policy S1 so that we're absolutely clear about this, page 30, and what the local plan tells us to do. So we can see that it talks about positive contribution towards sustainable development and improving economic, environmental, social conditions. In that respect, this policy is up to date, isn't it, in accordance with the NPPF?
Yes.
So then moving on to the first bullet, we can see there that it tells us, doesn't it, that what we need to do is ensure that we're meeting most development needs within or adjacent to existing communities, having regard to the defined settlement hierarchy. And what that means is that we should be thinking about the settlement hierarchy, even in cases where we're looking at potentially development on non-allocated sites because we have a 5-year supply problem. Can we agree that?
Absolutely, yes.
And then we can move to policy S2, please, which is the settlement hierarchy. And again, policy S2, what that tells us is that new development will be directed towards most sustainable locations in accordance with the following settlement hierarchy. This will ensure, that's the language of the policy, that development reduces the need to travel and promote sustainable communities. So it's quite obvious, isn't it, that what policy S2 is telling us in combination with policy S1 is that if we're in a first tier settlement, even if we're on the edge, because obviously S4 encourages that approach. It says do this in accordance with the settlement hierarchy if you need to meet your 5-year supply issues and shortfalls. If we take all of that into account, it's quite obvious that the plan considers that development in those first-tier settlements is sustainable. That's what it expressly tells us, isn't it?
Yes, I do accept that, yes.
And we also know that Ashbourne is, of course, the first tier, and that it tells us in policy S2 that that is a primary focus for growth. Can we agree that?
Yes, we can.
So if we need more homes, we go there first, don't we? First tier settlements.
Yes, we would, yes.
So in respect of your paragraph 2.12, again, just want to be clear about this. You make comments there about pedestrian cycle provision and connections and bus stops, car dependency, etc. I think we're already agreed on this. I'm just making sure and double sure. If Mr. Price's evidence is preferred by the inspector, then that point falls away entirely, doesn't it? Because you're relying entirely on Mr. Carey.
That's correct, yes.
And can we agree in principle that an absence of a footpath to Premier Avenue does not in itself render the proposed development unsustainable?
I think it does render it unsustainable insofar as, the policy is very clear that it's about having a choice for people to have, and the scheme doesn't provide that choice.
Okay, so again, just to be absolutely clear about this, you're inviting the inspector to conclude that the absence of that footpath is basically a big black mark against this development?
Yes.
If we can go to policy S1, please, page 31 of the plan. I just want to have a look at the final bullet, which is on page 31. We can see there, can't we, that what the plan asks the authority to do and developers to do is to ensure that development proposals do not prejudice the development potential of adjacent sites or the larger area in a comprehensive manner. The Redrow site that's to the north of the appeal site, quite simply, that development failed to comply with this part of the policy, didn't it? By not providing a potential connection up to the site boundary.
Ma'am, I'm sorry, I'm unable to answer because I wasn't involved in that particular scheme, and I don't know what Vodro have control of. So I'm unable to answer that question.
That's fine, I'll ask Mr. Bassett. There was a point about policy put to Mr. Carr about compliance with the National Design Guide, and I just want to see if we can agree this in terms of an overall approach to policy. So if we just pick up paragraph 139 of the framework, please, just to understand interpretation, see if we can agree it between us.
Oh, it's right in front of me. Sorry, what paragraph?
Not at all. It's para 139 on page 41.
Okay.
Just if we look at the first paragraph, it says development that's not well designed should be refused, especially where it fails to reflect local design policies and government guidance on design. So this question is predicated on the basis that basically the council's case is not correct about well designed, but if there was a minor or limited failure, if you want to put it like that, to not entirely reflect the National Design Guide and what that document tells us and doesn't tell us, this paragraph doesn't say if you are in conflict with the National Design Guide in any way whatsoever that development should be refused, does it?
So can I be really clear the question that I'm answering here? So the question that I'm being posed.
Do you want me to put it again?
If you wouldn't mind, thank you.
Of
If you're not
course.
saying a number of caveats, if you just.
Yeah, of course.
Sorry, I want to make sure I answer.
Yeah, I'm trying to be fair, but perhaps I could be clearer. So let me try and just break it down. The first sentence says development that's not well designed should be refused. The question is, if you don't comply with every single part of the National Design Guidance, does that necessarily mean that your development is not well designed?
No.
That's helpful. So the approach we have to take from a policy perspective is the development well designed, looking at it overall holistically, and of course we have regard to the National Design Guidance.
Yes, of course.
Yeah.
Yes.
Can we then go to paragraph 39 to 41, please, of the framework?
So you said 139.
39.
Oh, sorry, I thought it was 139 as well, sorry, 39.
39. What we see here, it's a section on decision making for applications, isn't it? And we're told at paragraph 38 that local planning authorities should approach decisions in a positive and creative way. It then goes on to talk about early engagement at paragraph 39, good quality pre-application discussions, and local planning authorities having a key role to play throughout that process. And I just want to ask you about this. It is important, isn't it, that a developer engages with a local planning authority either before the application is made or during the application process itself?
Absolutely.
Yeah. And here we had extensive engagement, didn't we, on design matters?
Certainly from the information I read and also from the oral evidence that I've heard during the inquiry, yes.
And we also had extensive engagement with relevant statutory consultees, particularly on highways. Would you agree that that's a fair characterisation?
From the information that I have read, I'd say that's fair, yes.
And the same goes for the lead local flood authority.
I've only seen a couple of emails on that, as opposed to, so I haven't got anything to dispute that comment.
I think from your evidence in chief then, we're agreed about the role of a Sheila, but just to be absolutely clear, it is only a high-level assessment of a site, isn't it?
It is, yes.
Yeah. And we do have to be careful, don't we, and cautious about how much reliance we place on that.
Absolutely, yes.
When it comes to technical issues, can we agree that it's important that local planning authorities have regard and give weight to consultation responses from statutory consultees?
Yes.
Can we also agree that local planning authorities shouldn't refuse on technical grounds in the absence of technical evidence?
I think, no, I don't agree with that one. Where you have a situation where, in this particular instance, where there may be a lack of information, in this particular case, the case officer done his report, it's gone to planning committee. The planning committee, they are the determining body. If they feel that there is information that they haven't got, and they can't make a decision or then obviously it's within the committee's right to say, well, actually, we need further information or we want further clarity. That is the whole democratic process of our decision making within local authorities. So it doesn't always follow that you have to follow. It's the ultimate decision maker is the local planning authority.
And it's also fair, isn't it, that what local planning authorities shouldn't do is refuse applications where development can be made acceptable by condition. Can we agree that as a principle?
That is a principle that, yes, I do agree with, yes.
And again, I don't think there's anything between us on this, and again, helpful to have that clarified in evidence in chief, but on either case between the council and the appellants, when it comes to housing land supply, what we do know is that we've got a shortfall in 5 years supply delivery on housing.
That's correct.
Yeah. Paragraph 23 of your proof, I don't think you need to turn it up because you've already gone to it, but you already adduce significant weight to that.
Yes.
And it's fair, isn't it, to say that when we're looking at plans and housing numbers, that there isn't any sort of cap or maxima, is there, on housing requirement delivery?
No.
Can we go to CD 7.19, which is the housing land supply on Statement of Common Ground, please? You can dig that out for me. If you can go to page 10 when you find the document.
Okay.
Version, I've got a 6-page version.
I was going to say, yeah, mine goes up to page 6, sorry.
I was working off an earlier PDF that I don't have with me.
Could you just tell us which part you want to go to and see whether we...
Well, there was a final table on it that I was going to go to, which basically demonstrates that we've got 13 dwellings being delivered from allocated sites over the next 5 years.
So the one I've got is dated the 17th of April 2024.
I've got a later. I think you might have another version, so we might need to get hold of the right one. Can you tell us the date of your version?
I'm sorry, I can't, because as I say, I was working from a CD 7.19. It's track changed, yeah. So it is the same one, isn't it? It's the same one. It's still CD 719, and it's page 10 of 11 of the PDF.
Sorry, I think we've got different. I appreciate. I didn't get the version that came in the core documents for some reason. I've got a 1st of May version, but is there is the tables are numbered in my version? Are this numbered?
It's table 5.
Table 5. I have that. Is it the one that says how the land supply position of the parties and then commitments?
Yeah.
Yeah, great. I think that should be in all of them then. Yeah, and I'm not sure it'll have changed, so that'll be hopefully.
I don't believe there's been any change to this.
Yeah, thank you.
Are you there,
I have
Mrs.
a table
Ford?
5, yes,
Yeah.
and I have a total supply council's position 1,096 and Lambert Smith Hampton's position at 646.
Yeah, well, there was a track change version that came after this, so I think we need to make sure that you've got the right one.
I haven't got that one,
Okay,
sorry.
let me just see if it's dealt with in the document that was handed out today. Is it broken down in there? Sorry, Mal, I think we're going to have to get this document so everybody's got it.
Yeah. So it's the local plan allocation, the section you're interested in?
It is, but I need this particular table, and it should be in the core documents. I can't explain why that isn't the case. Is it possible for us to send this to you, Mr. Robson? So I'll just ask Mr. Bassett to help me out, because I think we'll need a copy for Mr. Hunter for the inspector potentially, as well as for Mrs. Ford. Yeah. Are the track changes in it, ma'am? No. You might still not be quite the right one then. Sorry, just while we're waiting for that to be handed out, perhaps there's something else that I can pick up very quickly. Are you content for me to do that, ma'am? Just going back to the footpath to Premier Avenue, and just that point alone, I just want to understand this. If the issue on broader design and highway safety were resolved, I appreciate that's not your case, not the council's case, but if it were, would you be inviting the inspector to refuse the development on the absence of a footpath to Premier Avenue alone?
No. And I think just to caveat that, planning is all about balancing, and planning is all about, taking into account a whole range of different issues. So I would think it would be unrealistic of me to say to anyone on this one point alone that you would refuse the scheme. Everything's on a balance, and you weigh up the various advantages and disadvantages. So no, I would not do that.
Thank you. That's helpful.
Thank you.
Thank you.
Sorry, ma'am? Oh, thank you.
Yeah.
So apologies, I've got this as core document 7.19, so sorry about that. But now we've all got it, it will make sense that because there are enough pages for there to be a 10th page. And table 5, of course, the numbers have changed slightly in paragraph 3.1 and 3.2 on the text underneath table 5. But where we get to on local plan allocation delivery is still unchanged between us, as I understand it. Do you want to just check that for yourself? So it's section 3, second to last page of the document, table 5. Have you got that? Yeah. So can we agree that insofar, I know there are some changes on windfall and the commitments, but there aren't any changes as a result of the session today on local plan allocation delivery, is there?
No.
So this is the agreed position as it stands in front of the inquiry today?
As far as I'm aware, yes.
Yeah.
Yes.
Yeah, Mr. Robson, very helpful,
Yeah.
thank you. So what we can see there, can't we, is that in terms of local plan allocations, that we're only looking we're only expecting 14 units to be delivered from local plan allocations over the next 5 years. And that is properly characterised as a real crisis in housing delivery, isn't it?
It would all depend on what's gone previously, but so I'll have to look at the table. I haven't been involved in the 5-year housing land supply calculations in detail at all, but it depends on what's come previously. If you've done loads in advance, and I'm quickly looking at to see what has been done, then it won't be a crisis. But obviously, if you haven't delivered and you've still got, this is the only ones coming forward, then that would be a problem.
And it would be a problem that would be both chronic and acute, wouldn't it?
Yes, it would.
Can we go to CD 5.11, which is the local development scheme? Page 9 of that document, please. Let me ask you this question. Oh, sorry, do turn it up, sorry.
No, I have got it. Unfortunately, I tend to have this error message comes up occasionally on my Adobe, but it's fine, it's gone, so yeah.
It gets in the way of seeing the bit you need to see. So page 9, we can see that there's a programme for a local plan review. Do you have any instructions, are you aware at all where that process is up to?
I'm aware that the council actually is currently out on consultation at this point in time. I think it must be at the very early stages, but I'm not quite sure exactly which stage it is at, but I think it's at the early stages of the local plan review.
I don't think there's anything between us on that if we're agreed that it's very early stages then. Do you know whether or not the focus is continuing on the top tier settlements?
I don't know.
Given that we're at the very early stage, it's pretty optimistic, isn't it, to think that we're going to have a new local plan adopted by 2026?
I don't know what issues the local plan will cover, whether it's going to be a wholesale new plan, or it's review, and the stage it will go through and the issues it will have to cover. So from the timetable that's set out here, it is saying that it's looking to get an inspector's report, and apologies is corrupted slightly, by March 2026 in this document. So, but I accept that local plan inquiries, so sorry, it's just doing it. So look at adoptions of modifications in March 2026. So we're looking at least 2 years away.
But you don't know what that review is going to cover exactly?
No, I don't.
No.
No.
So So given that we've got a real crisis in housing delivery that's both chronic and acute here, given the timeframes, even on best case, that are being provided for a local plan review, it's fair and right, isn't it, to say that there are simply no other mechanisms for meeting the shortfall in housing land supply other than doing what the local plan tells us to do and granting a few permissions for unallocated sites on the edge of sustainable settlements.
As long as those settlements are in accordance with the other policies and the MPPF, but then yes, there is the flexibility within the plan to allow developments to go ahead, yes.
Yeah, but there aren't any other mechanisms available, are there, in the short to medium term here?
No.
Can I then take you, please, to Mr. Bassett's evidence?
Could I just raise one point of concern about that? That was a housing land supply question. Mr. Hayes isn't in the room. I have some re-examination on it because I think it depends on the series of premises. But I'm just plugging up. I'm going to ask some questions about that.
Sorry, ma'am, I'm confused by that because neither party has sought to cross-examine on housing land supply in terms of that particular point, and the roundtable, which we all agreed, was only there to deal with delivery. This is in Mr. Roberts' evidence.
Yes, sir. I'll explain my concern and then see where we go with it. There was a series of things you said. Basically, it started with there's only 14 dwellings in the column for local plan allocations in the 5-year supply, and then there's a series of questions. If that's all there is in the supply, that would be a chronic and acute problem. And well, as I understood it, so if I misunderstood, tell me this. But I think that makes a whole host of presuppositions. And I think really that would have been an issue if it's going to be put to a witness. It was to Mr. Hayes. I appreciate it was a round table point, but I'm not sure Mr. Hayes would have agreed with where you're going with that. And so I'm going to have to ask, I think, probably some questions of Mr. Bassett as well on it. And I just wanted to be clear that that's where I'm going to go. Yeah, thank you.
Can we move along, please, to then agree between us?
Yes.
Yeah, thank you. To mix, I think. To mix, yes, ma'am. If we could then move on to paragraph 5.66. An affordable.
So just so we're clear, Mrs. Ford, so you've helpfully done a table at the back of your proof where you've put the benefits and the appellant's weight and your weight or the council's weight. So we've got housing, obviously, right at the top.
Yes.
Which has got significant weight.
Yeah.
Can we add in mix there, which also has significant positive weight? So I've just been keeping a tally. So I make that now 2 significant positive weights, 2 moderate weights. Is that correct? All in favour, if I'm just looking at the benefits.
I think I just draw attention, Ma'am, that when I did this table, this was based on the statement of case. I am conscious that since I've seen Mr. Bassett's proof, Mr. Bassett has altered some of the weighting that he has given. So I'm just raising caution in relation to looking at the weight that I've attributed to the appellants, because this was.
Oh, don't worry about that.
Okay,
I'm just concerned with yours at the minute.
Yes, of course. Yes.
So we've got significant weight for housing, significant weight for mix as benefits, and then we've got a moderate benefit of biodiversity and moderate economic benefits, and I think that's it, isn't it?
Yes.
Yeah. Okay. Lovely, thank you.
So if we can move on then, please, to paragraph 5.66 of Mr Bassett's proof of evidence. About affordable housing, I don't understand there to be any challenge about this from the council, but what we can see there is that from a period of 17-18 to 2023, the council's only delivered 58% of its affordable housing needs. Can we agree that between us, please?
I haven't got any evidence to the contrary, so yes.
And can we also agree, it goes on to explain that there's been a significant drop in affordable housing in the last 4 years.
Again, yes, I haven't got any evidence to dispute that.
We can see that on that basis then, because I'm hoping that's really a yes, that if we take affordable housing needs separate from the delivery of market housing, we can see there that we also have an issue with acute and chronic undersupply. Is that correct?
Yes.
I'm not sure there's anything really between us on this apart from potentially semantics, but Mr Bassett then, I believe, says at paragraph 5.62 that he attributes substantial weight to the contribution of the scheme to the delivery of affordable housing. Can we agree that between us, please?
Yes, I have put that in my table. I have included that as well.
And again, in terms of mechanisms for addressing the shortfall, there are no other mechanisms on the table, are there, apart from allowing some permissions to come forward?
No.
Isn't it a case where the council can say, oh, well, it's going to be all right, we'll have it sorted out in 6 months? We're just not in that world, are we?
No, we're not.
Ma'am, I'm really conscious that I'm coming up to 3:30, and I don't know where to draw the line in terms of us
Maybe
being out
now?
by 4.
Maybe now?
Yeah.
Sorry to be fussy, but can we just go back to your table, Mrs Ford? Because just following on from, so I noticed that the first benefit, so housing, and that includes affordable housing, and you've given those significant positive weight. And then I asked you about mix, which you agreed significant positive weight. Are you lumping that in, or do I take it as 2 lots of significant positive weight?
I'm quite happy for the housing mix to be included within that overall housing, because
Okay.
my whole point is I accept that housing has a significant positive
Altogether.
weight in this scheme. Absolutely, there's no
Okay.
dispute there.
All right. Is that okay with you? It doesn't change anything?
I don't think so.
Okay. Okay, right. So that's a good place to stop.
Yeah.
So we should have about another half an hour tomorrow?
Yeah, about that. Half an hour, 40 minutes.
Okay, let's just have a quick look where that might take us in terms of timings.
Yeah.
So we're going to have, so there'll be a bit of re-examination, 10-15 minutes, okay. An hour to an hour and a half examination in chief. Sorry.
Yeah, about that. It might depend on where the re-examination goes. I'd have to wait and see where we go on that. But at least I've got advance notice, and I'll try and prepare on that basis.
I think we may be able to finish at about 3 then tomorrow.
With a fair wind, yeah.
Yep.
Yeah.
With no hiccups. 3-ish, yeah, but that's not too bad on a Friday. Okay, all right, thanks everyone. Anything else we need to do before we adjourn for today, other than,
Just the route map, sorry, Miss.
Yes, there was one suggestion.
oh yeah, that's quick work. I'm not going to do it today now, no, but that's fine because I'll be coming back in the rush of tomorrow. It's good to have it now. And so well done for turning it out, that's really good. Sorry, when I said, I'm going today, you probably thought,
Yeah, I just want to check that ours are the same because I've made some annotations.
The annotations.
I mean, if you want a bit more time, you could send it ready for next week.
Mark, the only one I was going to suggest, and it became point on top of this point here, because I know there was the...
Is that the...
That's up next to the other one.
Is that the venue?
Yes.
Yeah, that's on my list anyway.
Okay, that's fine.
That's fine. I'll just explain this to you, Mark, so you understand the scroll. So you've got the sides where we think, obviously entirely up to you, but and then I've crossed a couple out here because I don't think they're necessary.
Okay.
And then I've things that
Added those.
come up coming during the evidence. So again,
Okay, so it's all the blue stars.
yeah.
And then it's the golf club
These things are covered in
entrance.
evidence, but actually the aerial photo doesn't include it.
No,
so-
that's fine. The venue and viewpoint C. Is that the one at the gate?
It is, yeah.
Yeah, got it. And this includes the adjacent developments and so on, is it?
Yes,
Yeah, it does, yeah.
Yeah. Okay, that's really good, thanks. I'll make that inquiry document 16. Right, are you okay to start at 9:30 tomorrow? Yep.
Time for me. Sorry, I'm not travelling. Yeah, Mr. Hunter, maybe.
It's just one of those days where I have something else to do beforehand, and it should be fine, traffic permitting, basically. But
Okay. You'll aim for half. Okay. We'll just start without you, it's fine. Joke. All right, yep. We'll aim for 9:30 tomorrow then. Thank you.
Thank you, ma'am. Right, let's get sorted. All right? All right.